The bill outlines a process for the reorganization of a Native Hawaiian government for the purposes of reestablishing a government-to-government relationship in the United States and with the United States. It also reaffirms that the Native Hawaiian people have the right to provide for their common welfare and to adopt an appropriate governing documents or a series of documents as they reorganize a government. We as Congress have a distinct and undeniable trust responsibility towards the first Americans of the United States, and with the passage of this legislation, the Native Hawaiian people will once again have an opportunity for self-governance and self-determination. This, I think, is an important step for our country in an attempt to redress the wrongs that our government has committed against the Native Hawaiian people.
As members of the Senate Committee on Indian Affairs, we have jurisdiction to examine and address the needs of our country's indigenous people. This specifically includes Native Hawaiians, Alaska Natives, and American Indians. The United States has not always acted honorably in its treatment of our nation's first people. However, I am proud that as a country we have pursued actions acknowledging past wrongs and building a mutual path forward. It has been the work of this committee and Congress to advance policies that uphold Native rights and their ability to exercise self-governance and self-determination. The legislation before us today provides parity. It enables Hawaii's indigenous people to establish a government-to-government relationship with the United States. This political and legal relationship is the same type of relationship natives of Alaska and tribes in the lower 48 states have with the United States. Further, the process is consistent with the Constitution, federal and state laws. Those that are not familiar with the history of Hawaii may wonder why such a process is needed. It is needed because in 1893, the Native Hawaiian government led by Queen Liliuokalani was illegally overthrown. The overthrow resulted in generations of Native Hawaiians being disenfranchised from their government, culture, land, and their way of life. S 1011 provides a structured process to reorganize a Native Hawaiian governing entity to exercise self-governance and self-determination. Once federally recognized, the Native Hawaiian governing entity can enter into discussions with the state of Hawaii and the United States. Any agreements reached by the three parties will require implementing legislation at the state and federal level. Such actions enable us to honor the needs of our state, preserve its cultural heritage, and address issues that have lingered without resolution since the overthrow of the Kingdom of Hawaii.
Mr. Chairman, I thank you and Vice Chairman Barrasso for scheduling this very important hearing on the Akaka bill. We've waited many, many years for this.
But I also want to take just a moment and let my Hawaiian colleagues know that for yet another round, the Alaskans will stand by you as we try to advance this important legislation for recognition of Native Hawaiians. It's something that we've been working on for many years, and I think some of the questions that come up about, well, how will this work in Hawaii can be resolved when you look to how we have handled the recognition of our Alaska Natives. And please know that I will be working with you as you advance this legislation.
The Department of Justice strongly supports the core policy goals of this bill, and I'm very pleased to testify on this historic legislation today. As for Native Hawaiians specifically, the Supreme Court has never decided whether Congress has the authority to treat the Native Hawaiian community in the same manner as an Indian tribe. Indeed, in its 2000 decision in Rice versus Cayetano, the court expressly avoided that question, calling it, quote, difficult terrain. And in the decades since the Supreme Court decided Rice, no court has squarely addressed that issue. In recognizing a Native Hawaiian sovereign entity, then, Congress would, in effect, determine that Native Hawaiians constitute a distinct Native community akin to an Indian tribe. And the general history of the Native Hawaiian people bears significant similarities to the history of Indian tribes. Despite numerous obstacles Native Hawaiians have a sustained history of acting collectively and creating institutions to preserve traditional Native Hawaiian forms of social organization, religious practice, family and cultural identity, and other distinctive cultural practices. Congress has enacted more than 100 federal statutes expressly recognizing Native Hawaiian tradition and culture and providing benefit programs for Native Hawaiians similar to those provided to other Native people. None of those statutes has been struck down as unconstitutional. And collectively, these congressional enactments have provided Native Hawaiians with significant benefits in the areas of healthcare, education, and housing, among others. The Department of Justice strongly supports the core policy goals of the Native Hawaiian Government Reorganization Act of 2009 and looks forward to working with you as the bill's specific language further evolves. We are very pleased to have the opportunity to work with this committee and with the bill's sponsors and co-sponsors and their staff in developing this historic legislation.
There are claims that Native Hawaiians would be able to secede. As you understand the bill, Mr. Hirsch, does the legislation permit secession?
Senator Akaka, absolutely not. There's absolutely nothing in the legislation that I see that is remotely relevant to that alleged risk.
Some suggest that once the Native Hawaiian governing entity is recognized, it will acquire a significant amount of authority from the state and federal governments to the detriment of non-natives that are not under its authority. Are such claims grounded in law or reality? Has this happened in Indian country or Alaska? As their people have exercised self-governance and self-determination?
Thank you for that question. My reading of the bill as it currently stands is that it has a provision expressly protecting against this potential problem. It says that jurisdiction currently exercised by the United States or by the state of Hawaii cannot be transferred to the Native Hawaiian governing entity unless all three sovereigns agree and come back for implementing legislation to this body and to the legislature of the state of Hawaii.